Our next guest is really surprised by the decision, says it'll send ripples across multiple sectors of the economy. Joining us for more is James Lucier, Capital Alpha Partners Managing Director, and NBC News and MSNBC legal analyst Danny Cevallos. Welcome to you both. James, were you surprised?
I was not surprised that they did the ruling to repeal Chevron, but this is a big one. Roberts literally dropped the big one. It's total, complete, and across the board. It's not nuanced. It's not, well, sort of, kind of, let's adjust things. It's like Chevron is gone. The courts are in charge of interpreting federal statutes. The agencies have to listen to the courts. This is a complete reversal of Chevron, and it'll have great impact over time. That's
what struck me as well, was the nature of it. This has been a court that in some ways has been a little bit cautious, and they did not at all kind of nod towards what others have said. Hey, deference to the 40 years of history. No, they go back to that ruling, say it's overturned. Where does that now leave? I mean, which agency would you think is immediately most vulnerable, or which rules immediately do you think stand to be most challenged?
Is that for me, Kelly?
Yes, go ahead. Sorry.
Oh, absolutely. EV regulations, I think, are most at risk and soonest at risk. We can see those get to the Supreme Court by various pathways as soon as this fall. Otherwise, I think the EPA's power plant regulation is also very vulnerable to a stay. And finally, the idea of climate regulation through a whole of government system where you try to find statutes that give you some basis for doing what you want and you interpret them creatively. All of that is in big trouble now.
Danny, what would you add?
This was always about who decides the law. And ever since Chevron was decided, where the law was ambiguous, the courts gave deference in interpreting the law to regulatory agencies with really two main ideas. Number one, the agencies usually have the experts. So if we're talking about an agency devoted to fishing, that's the agency that has the people who know about fishing. And the second thing is that those people in those agencies are accountable to the extent that they can be fired. Federal judges they serve for life. They're appointed and serve until they're impeached or they die or step down. So they don't have the same accountability and they don't have expertise. But what they do have is a constitutional directive to be the only branch of government that interprets the law. Executive agencies traditionally don't have that prerogative. But ever since Chevron, when the law was ambiguous, there was that deference to those federal agencies.
Right.
That is no longer the case. Now it is the courts that decide the law. Chevron was on the chopping block for years. This came as no surprise.
But let me just stop you there. So, and so people understand it, and those following this obviously know the stakes, but broadly speaking, when the law from the legislative branch is at all unclear, it's allowed the executive branch to increase its power. In other words, to increase the political power, the power of those who are holding the office for that 4 or 8 year period of time in a very broad way. That's why we look and say, what's the impact of the SEC going to be? What's the impact of this and that across markets? How much does this ruling now trim the sails of that power in a very substantial way, or only at the margin, Danny, do you think?
Yeah, you bring up a really good point. We learned in civics class in school that it's the legislature that makes the laws, but that's not entirely true in our system. We know that judges can make law by deciding cases, but the executive branch technically makes law. When Congress passes a law, the executive branch interprets it through its agencies. They put out regulations, the Code of Federal Regulations, for example, and those have the force of law. So the executive branch, in that sense, does create law through its agencies, and Chevron stood for a deference by the courts charged with interpreting that law to those agencies. Now, this case, it's been 40 years since Chevron. This totally upends that approach. It doesn't necessarily mean the mass chaos. It could, but not necessarily. Even Justice Roberts noted at oral argument that, look, Chevron doesn't even come up that often, but there's a really good point to be made there. What the heck does Justice Roberts know about business and regulations on the front lines where it's actually happening? He, of course, is in the cloisters of a federal judgeship, so he doesn't really know it on the ground the way people who actually live it know it.
James Lucier, what would you add? And beyond the kind of the climate areas that you've mentioned in particular, where they might have taken advantage of that gray area, what are some other areas that investors might need to pay attention to?
Great examples are network neutrality, a lot of healthcare regulation where the CMS or some government agency gets the decision to make gets the opportunity to make decisions on healthcare. labor law, it really is, as you said, Kelly, comprehensive and across the board. The climate tends to come up because that's an area where we have no new laws. We're trying to do climate policy based on laws from the 1970s. So that is critical, but it really does apply to telecommunications, to healthcare, to labor, and to financial services. And a good financial services example would be the climate disclosure rule. I'd like to add two things. One is that we don't know how far back this decision would reach. There's another decision coming up called Corner Post versus the Federal Reserve Board of Governors that will tell us just how far back some of these decisions could be challenged. And then also there is a rule for the states. We talk about Congress, the executive branch, and the judiciary. The argument is that Chevron has diminished Congress, has preempted commerce, and it's also allowed the courts to fail to serve their function. But if you look at these big cases challenging EPA regulations, they're all being brought by groups of states that feel that the states have been losers to Chevron too.
Interesting.
And another good example of that would be the Good Neighbor Plan, which the court stayed yesterday. 25 states said, hey, what about us? This is not fair to us. And it sort of pre-shadows where we're going, giving not only the three branches of the federal government, but the states the rightful authority too.
And Danny, it's interesting coming in tandem with the debate last night, because there are those who are already asserting that if Trump were to win in the fall, his administration under his administration, these powers could be substantially reduced, the agency powers. Do you think that's a possibility?
Yes. I mean, no surprise that if Trump fully grasps what's going on with this Chevron decision, then yes, he might use that as justification, or it might embolden him to enact policy that would be essentially immune from agency interpretation. Now, look, that doesn't mean that agencies won't still issue regulations, and it doesn't mean that they don't still have the force of law. It just means that when they're challenged in court, that the court reviewing them has the primary responsibility for determining the law. They don't have to show that deference to the agency interpretation, because under Chevron, as pointed out at oral argument, all 9 justices could interpret the law one way, but they would be forced under Chevron deference to defer to a non-judge, an agency, an unelected, unappointed agency's determination of what those regulations are. So regulations still exist. They'll continue to exist. It's just what happens when they get challenged in federal court.
And we can imagine it will invite a lot of challenges now. As Kagan wrote in her dissent, longstanding precedent at the crux of administrative governance falls victim to a bold assertion of judicial authority. So quite the day. Danny Savalos, James Lucier, thank you both very, very much for explaining it. We appreciate it.